Elizabeth Ciders has been in jail since June 30th, going on 2 months now, and she wants out. Who wouldn't? Elizabeth's attorney has asked the judge to modify her bail, but the prosecutor has now responded in writing, and William Archer is essentially saying, not so fast, Judge. Keep her in. And his reasons for that are interesting.
Elizabeth Ciders has been in jail since June 30th, 2 months, and her lawyer has now asked a judge to release her. The prosecutor's written response arrived like a drawer sliding shut. Not so fast, Judge. Keep her in. Before we go deeper into what the documents actually show, make sure you're subscribed to Trial&Crime, because we don't just cover the story, we follow the evidence.
Respond as it stands right now. Archer wrote in a memorandum opposing the request for bail modification. This court should deny the bond modification for several reasons. First, the defendant is facing multiple serious pending charges, multiple F2s involving serious physical harm to her children, and thus is a flight risk and a potential risk to the...
William Archer's memorandum opposing bond modification reads like a checklist of escalating alarm. Reason 1, the defendant faces multiple serious pending charges, multiple F2s. That is legal shorthand for felonies of the second degree, crimes involving serious physical harm to her children. In plain English, the state says she is a flight risk and a potential risk to the victims.
In this case. Second, the defendant has filed a competency motion. Consequently, she is at personal risk until her competency is known. Third, the defendant has new serious felony charges that will be considered by the grand jury. Did you catch that last part? William Archer.
Reason 2, a competency motion has been filed. The judge has already ordered a psychological evaluation. The prosecutor argues she remains a personal risk until her competency is known. Think of a locked evidence room where the light switch is on the outside. The room is occupied. No one can enter yet. The paperwork already new.
Felony charges that will be considered by the grand jury. Did you catch that last part? William Archer wrote that Elizabeth Ciders has new serious felony charges that will be considered by the grand jury. That sounds like those charges are in addition to the 16 child endangering charges she already faces.
Then comes reason 3, and this is where the memo stops being routine and starts being a warning. Archer wrote that the defendant has new serious felony charges that will be considered by the grand jury. Read that again. New charges. In addition to the 16 child endangering counts she already faces.
There's also another little tidbit of information here, very interesting and very important bit of information regarding Elizabeth Ciders. The prosecutor says that she's already facing these 16 charges of child endangering, and these are F2s. And that includes causing, basically serious harm to a child. It's neglect, not providing a safe environment, causing serious physical harm, things of that nature. But he's saying when this goes to grand jury, he's going to ask the grand jurors to indict her on new charges. So that makes me think this is in addition to those 16 child endangering charges. What does that say to you? Because I don't know what other charges. My mind is spinning. What other charges?
The phrase sits on the page without elaboration. No list, no statute numbers. Just a door left slightly open. The former Franklin County prosecutor called it the most striking thing in the memo, the state showing cards to the public and to defense counsel. Look at these 16 charges. There is more coming, and it is more serious.
Bond, and I think it's showing some cards to the public as well as to defense counsel that, look, you're looking at child endangering cases, but there's more coming, and it's more serious, and that is also why she might try and flee. And that's also why she might try and reach her children to talk to them, to influence them one way or another in what their statements may be in relating to the endangering children, but any other offenses that may have occurred while they're locked in this small room for many years. The key to this, I think, is, among other things, is it's long goal.
Why does that matter for bond? Because every additional felony is another brick in the wall of motive to flee. Decades in prison will do that. A woman with no money, no outside support, and no stable address becomes, in the state's arithmetic, a flight risk by default. The calculus is cold. The logic is not wrong.
William Archer also said that Elizabeth is a potential risk to the victims in this case. Now, these potential victims, the 16 children ranging in age from age 18 to 1.5, they're all in therapeutic foster care. So, you would hope that, she's not going to be able to learn their location since she is accused of endangering the children. But this is interesting to me that a prosecutor thinks she's a potential risk to their safety after her lawyer, Tommy Stolly, has said publicly, like, she wants to be reunited with her children. She loves her children. She's getting care packages at the jail and she's asking, can I give this stuff to my kids? So it sounds to me like there's a lot here under the surface that we don't know about. When you read between the lines of this, what does it say to you?
Archer also labels Elizabeth a potential risk to the victims. The victims are her children, 16 of them, ranging from age 18 down to 18 months. They are now in therapeutic foster care. The county is not asking for temporary custody while things get sorted out. They are seeking permanent custody. That is the legal equivalent of saying reunification is not the goal.
There's not going to be any reunification. If the county is saying to the courts, we're seeking permanent custody of these children, I think that is signaling that this is incredibly serious and reunification is unlikely.
I think you're exactly correct. This case, ordinarily this kind of case, even though this is a case of its own, exclusive kind, a case like this starts with a request for temporary custody to children's either on an emergency basis or otherwise, and then you do an investigation, you see what you have, and then you look at the family unit and look at relatives or others that the child might be placed at. But here, they're starting off right from the get-go, seeking permanent custody, which
Ron O'Brien put it plainly. In a typical case, you start with emergency custody, you investigate, you look for relatives, you build toward reunification. Here, the state opened with permanent custody. That tells everyone concerned, the parents, the grandparents, the defense attorneys, that the state does not believe these children should ever go back.
That goes beyond, these are just poor people living in extreme poverty, because that's what a couple of the defense attorneys have said thus far. They're just poor. They're living in extreme poverty. Ron, they're not in school. They're not going to school. They're moving around to avoid children's services. Does this not signal to you that this goes beyond just being impoverished?
And this is where the poverty argument collapses. The defense has suggested this is just extreme poverty. Poor people living in a poor county. But the children were not in school. The family moved repeatedly to avoid children's services. That is not poverty. That is concealment. Nobody asked. Nobody answered.
As things stand right now, we know what we know. We know that the 16 children were taken from the house on June 30th. We know that that 3 of the adults remain in jail. The children are in therapeutic foster care. This prosecutor knows a whole heck of a lot more than we do. He knows the inner workings of the investigation, what brought them there in the first place. He is calling Elizabeth a flight risk. Her attorney, on the other hand, has said that she doesn't have any money. She can't post bail, so you should just let her out and put a GPS bracelet on her. So is there maybe something this prosecutor is hearing on jail calls that she's might be saying to family members that's really raising his concern that she could potentially flee?
Then there are the jail calls. The prosecutor is listening. Every call Elizabeth makes to family or friends is monitored and recorded. O'Brien confirmed it. The only protected calls are with her lawyer. If Archer is hearing something on those recordings that suggests planning, coordination, or intent to flee, that would explain the flight risk language. We do not know what is on those calls. The state does.
Obviously, the placements for the children would not be known, but given the whole very bizarre circumstances surrounding this case, they probably have a concern that she might try and find out where the children are. Obviously, a proposed ankle monitor. We all know ankle monitors fairly regularly get, at least I have had defendants cut them off their ankle and no longer subject to monitoring, which would fit into their argument regarding flight as well as attempt to contact the children.
And the ankle monitor argument does not reassure anyone. O'Brien said it plainly. Defendants cut them off regularly. The alert goes out, but no one watches in real time. It is a look-back system. By the time someone notices, the monitor is in a ditch and the defendant is gone. The GPS is not a leash, it is a receipt.
So Grandma, Christina, William Archer says, we have not 3 reasons like we do with Elizabeth to oppose a bail modification for her, but we have 2 reasons. And the first is a similar reason. It says she's facing multiple serious pending charges, the F2s for child endangering involving serious physical harm to the grandchildren, and thus is a flight risk. So he's saying Grandma is also a potential flight risk and a potential risk to the victims in this case.
And at least it seems to me that the same rules apply to all of them, except perhaps maybe the grandfather, who seems to have sufficient mental health issues that he may not share the same kind of either flight risk or threat.
The same logic applies to Christina Ciders, the grandmother. Archer opposed her release with 2 reasons instead of 3. Multiple serious pending charges, flight risk, potential risk to the victims. What he did not include is that line about new serious felony charges. The absence is louder than the sentence. It suggests the grandmother is not facing what the mother is facing.
Position to her bail modification. What does that say to you?
Well, it says that mom and likely dad are the primary offenders here, and grandma and grandpa were in the house and maybe didn't take control, maybe didn't prevent them from causing the atmosphere that existed. But it sounds to me like they're more passive participants than active participants.
O'Brien read it the same way. Mom and likely dad are the primary actors. Grandma and grandpa were in the house, passive participants, present but not driving the conditions. The prosecutor's selective language draws a line between who allegedly created the environment and who allegedly failed to stop it.
And then we also have the competency issue that William Archer writes about, that basically she's at personal risk until her competency is known, because that's been raised by her counsel.
Right. And at least in terms of competency, they want to be assured that she's not a risk of harm to herself or to others. And that is something that would be looked into during the competency exam. And so at this point, I can see why they are saying, look, let's look at this. There's competency issues. There's flight risk. There's a potential harm to the...
And then the competency piece returns. Elizabeth's own lawyer raised it. The evaluation will determine whether she understands the charges against her and whether a mental illness defense applies. Until that is resolved, the state argues, she is a risk to herself. The phrase sits there: personal risk, not public risk, personal.
Grand jury, because they typically have 60 days from the time it's bound over to the grand jury, and they've already consumed, probably a month, maybe. In any event, they need to start getting the case together to present to the grand jury. And at that point, we will see what additional charges that have been waved around are included in the indictment.
Ron, you read my mind because that was going to be my next question to you. When do you see this case going to grand jury? Because it's been quite a bit of time now. Is this a case where maybe they only want to go once? They don't want to have to go back to the grand jury, on a continuing basis?
I think that's exactly right. I think they want to have what they are going to proceed on included in the single indictment against all defendants, and include all counts against each individual defendant. And they have a clock, at least under the rules of superintendents, of 60 days from the time a case is bound over from municipal court to common pleas court. And in this case, they're probably close to 40 anyhow, or more.
The clock is already running. Ohio's rules give prosecutors 60 days from bind over to present a case to the grand jury. O'Brien estimated they are already 40 days in or more. That means an indictment could land before Labor Day. One indictment. All defendants, all counts, the new charges would be in it.
It wasn't just one discrete child endangering where a mother burned a child on the arm, and that's the basis for the single child endangering. This went on for years, where they weren't sent to school, where they were locked up, that they weren't allowed out, that their life was very much restricted. All those things add up to an equation of a long-standing neglect and abuse that.
Here is the question that reframes everything. What happens when a grand jury sees evidence that 16 children were hidden, unschooled, and locked away for years? And what happens when that evidence points to offenses beyond neglect? What if the real charges have not been filed yet because the state is still counting? The paperwork already knew.
Elizabeth's bail is currently set at $300,000. If she's able to post it, which her attorney has already said she cannot, she will have to wear a GPS monitor. And remember, you can look at all of the documents, peruse through all of them on our Law and Crime Plus app. Check it out. We're going to keep an eye on all of this for you.
Elizabeth Ciders' bail remains at $300,000. Her attorney says she cannot pay it. The GPS monitor is a condition, not a guarantee. The public record contains no list of the new charges, only the phrase, new serious felony charges. 3 words in a memorandum, enough to keep a woman in jail.
And so at this point in time, I would think that it should go to the grand jury probably before Labor Day.
Well, we shall see, because we're all watching that calendar, and we'll see what happens. Ron O'Brien, thank you so much for your time and your expertise, as always.
Go look at the memorandum yourself. The full document is in the public record. Then ask yourself one question in the comments. What charges do you believe the grand jury is about to consider? And why do you think the prosecutor wrote that sentence without naming them? If you got something from this breakdown, like this video, share it, subscribe to Trial Crime, and turn on notifications. Because we will be here when the indictment drops.